Welcome to U.S. Immigration TV. Now, the Child Status Protection Act, or the CSPA, provides age-out protection for certain children beyond their 21st birthday, allowing them to be processed for a visa as though they were still under 21 years of age. Now, for employment and most family-based petitions, eligibility is a two-step process. Number one, calculate the child's CSPA age, and number two, make sure the child seeks to acquire a visa within 1 year of the priority date being current. Now, in a previous video, I discussed how to calculate your child's CSPA age. In this video, I will discuss how to comply with the sought to acquire requirement. Now, it's really sad because I encounter many CSPA cases where the child's age was calculated to be under 21 years of age, but their case was nevertheless denied or refused because they had failed to timely seek to acquire a visa within 1 year of when the priority date became current. Okay, so the question is, how does a child properly and timely seek to acquire a visa? Well, here are some critical things to be aware of. Number one, when does the sought to acquire time period begin? Well, the 1 year clock for seeking to acquire a visa starts running from the date the priority date became current on the State Department's monthly visa bulletin. Now, if 1 full year passes without the child seeking to acquire a visa, then they may not be eligible for CSPA benefits. Now, even if a parent is adjusting status in the U.S., and let's say the child is abroad and will later follow to join, that 1 year clock for seeking to acquire a visa still applies when the priority date becomes current and not when the parents ultimately or finally adjust status. Also, you have to be aware of when the priority date becomes current to meet that 1 year deadline versus making excuses that, maybe the National Visa Center or NVC didn't notify you until after that 1 year passed. It's not the NVC's responsibility to remind you about due dates and deadlines. Now, sometimes their welcome letter or other letters or notifications are sent out more than a year after the priority date becomes current or the visa becomes available. Or maybe the NVC may have notified the family close to the deadline, the 1 year deadline, but the family did not submit the visa forms until after that 1 year deadline. Now, how can a child satisfy the sought to acquire requirement? Well, there are several ways a child can satisfy the sought to acquire requirement, provided it is done within 1 year of when the priority date became current. One way is submitting a completed Form DS-260 Part 1 for the child or paying the fees within 1 year of the visa becoming available. Another way is if the parent is adjusting status in the U.S. and the child will be processing abroad, the parent must concurrently submit a Form I-824 within 1 year of the visa becoming available. Another way is filing an affidavit of support or Form I-864 that includes or lists that child. Another way of seeking to acquire a visa is filing a Form I-485 or application to adjust status on behalf of that child within 1 year of visa availability or the priority date becoming current if the child is in the U.S. and will be adjusting status. Or there can be some other concrete step on behalf of the child evidencing the child's desire to pursue his or her visa. Now, if the family missed the 1 year deadline for seeking to acquire the child's visa, there still could be hope if extraordinary circumstances exist. Well, what are extraordinary circumstances that could excuse the late or delayed filing? Well, some of these include serious illness or mental or physical disability during the 1 year period, or where they attempted to timely file an adjustment of status application, but it was rejected. death or serious illness or incapacity of the applicant's attorney or a member of the applicant's immediate family. Or, and this is important, if a person hired an attorney and it was the attorney who missed the 1-year deadline. Now, I want to be clear that for children of U.S. citizens, CSPA eligibility is much more simple and straightforward. The parent merely has to file the petition before the child's 21st birthday. The child has no sought to acquire requirement. The CSPA is very complex and confusing. If you have a child who is aged out or will be aging out and you believe the child could benefit from the CSPA, or if you missed the deadline and believe extraordinary circumstances exist excusing your missing that deadline, I would strongly recommend that you consult with an attorney who can evaluate your situation, perform the necessary and complex mathematical computations, and make sure you timely seek to acquire a visa and otherwise establish your child's CSPA eligibility within that 1 year. I hope you have found this video, and as well as the previous video I did on calculating the child's CSPA age, to be helpful and informative to you. I will continue posting videos which I hope you will find of interest, if not for yourself, then maybe for a family member or a friend. So therefore, make sure to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching. Really, thank you for watching and subscribing to this channel.